tenant can cost you $15,000 and 6 months of your life. Not hypothetically, not in a worst-case scenario. That's the real, documented average cost of a California eviction when you factor in lost rent, legal fees, property damage, and the time you'll never get back. And almost every one of those $15,000 mistakes starts in the same place, a rushed screening process where the landlord winged it. So here's what you're getting today. The exact step-by-step screening workflow that protects your rental income, keeps you on the right side of California fair housing law, and gives you a defensible paper trail if anything ever goes sideways. Every step, no gaps. Let's get into it. Before you post your listing on Zillow, before you answer a single inquiry, before you do anything, you need to write down your screening criteria. Not in your head, on paper. A physical or digital document that exists before the first applicant sees your property. This is not optional advice. It is your legal foundation. Here's why it matters more than most landlords realize. When your criteria exist before you ever meet an applicant, you eliminate the single most dangerous thing in tenant screening. Subjective, in-the-moment decision-making. That's where fair housing violations are born. Not because landlords are malicious, but because humans are inconsistent, and inconsistency looks like discrimination to a judge. Your written criteria should spell out the minimum income requirement, typically 2.5 to 3 times the monthly rent and gross income. Your credit score floor, your policy on prior evictions, your policy on criminal history, and your rental history requirements. If you require a credit score of 680 or above, that standard must apply to every single applicant. If you waive it for one person, you need a documented reason that has nothing to do with protected class status. Here's a story that illustrates exactly what's at stake. A landlord in Sacramento, self-managing a fourplex, got hit with a fair housing complaint because she approved a tenant with a 640 credit score after initially rejecting another applicant with a 650. Her defense was that the approved tenant had a stronger rental history. That might have been a perfectly legitimate reason, but she had nothing in writing. No criteria document, no notes. The complaint dragged on for 8 months, cost her thousands in legal fees, and she settled to make it go away. Written criteria would have been her entire defense. Your criteria document is your shield. Create it before you list. Keep a copy. Date it. Don't change it mid-cycle. Now here's where it gets interesting. Because California has quietly made the rental application one of the most legally loaded documents in real estate. Let's start with what you absolutely cannot ask. You cannot ask about immigration status. You cannot ask about source of income in a way that discriminates against Section 8 voucher holders. California law treats housing vouchers as a protected source of income. You cannot ask about prior arrests that did not lead to conviction. You cannot ask about a sealed or expunged criminal record. And you cannot ask questions that would reveal information about a protected class. Race, religion, national origin, familial status, disability, gender, sexual orientation, marital status, or ancestry. What you can ask: full legal name, current and prior addresses, rental history for the past 2 to 3 years, employment history, income documentation, references, and permission to run a credit and background check. Now about that background check, there's a cost issue you need to know about. Under California AB 2559, you are only allowed to charge applicants an application fee that reflects your actual screening costs. As of recent years, that cap has been tied to the Consumer Price Index and typically lands around $30 to $65. You cannot charge $100 as a profit center. You cannot charge different fees to different applicants. And if you don't actually run a background check, if the unit gets rented before you screen someone, you must refund that fee. Keep your receipts from your screening service. That's your documentation if someone challenges the charge. One more thing on applications: use the same form for every applicant. Not a different version, not a modified one based on who's asking. The same form every time. A credit report without context is just noise. Most landlords look at the score and stop there. That's a mistake. When you pull a credit report, and you should always pull one from a landlord-specific screening service, not a generic consumer platform, you're looking for 3 things beyond the number itself: payment history patterns, the nature of any derogatory marks, and debt load relative to income. A 620 score with 1 medical collection and an otherwise perfect payment history tells a completely different story than a 620 score with 6 late payments, 2 charged-off accounts, and a prior eviction judgment. Same number, radically different risk profile. On income verification, The 3x rent income rule is the industry standard in California. If your rent is $2,000 a month, you want to see at least $6,000 in verified gross monthly income. Note the word verified. Pay stubs from the last 30 days, 2 years of tax returns for self-employed applicants, or bank statements showing consistent deposits. Offer letters are not income. A verbal promise is not income. But wait, there's a catch. You must apply that 3x rule consistently. If you flex it for one applicant without documentation, you're exposed. If someone presents alternative income, like a large savings account, a trust fund, or reliable government benefits, you can consider it, but document your reasoning clearly. On criminal background checks, California restricts how you use this information. As of now, you must do an individualized assessment of any criminal history. Blanket bans on applicants with any criminal record are legally risky and increasingly challenged under fair housing law. The nature of the crime, how long ago it occurred, and evidence of rehabilitation all matter. When in doubt, consult a California landlord-tenant attorney before creating a hard criminal history policy. Most landlords call references like they're going through a formality. 2 minutes, a couple questions, thank you, goodbye. That's how you miss the warning signs that would have saved you months of misery. The first rule of reference checks: always call the prior landlord, not just the current one. Here's why. A current landlord who has a problem tenant has every incentive to give that tenant a glowing review so someone else takes them off their hands. The landlord from 2 or 3 years ago has no stake in the outcome, they'll tell you the truth. Here's a story. A landlord in the East Bay, managing 6 units, took over a rental from a previous owner and inherited a tenant referral situation. He called the current landlord of his top applicant. Glowing review, perfect tenant. He ran the check, approved them. Within 90 days, he had noise complaints from neighbors, 2 bounced rent checks, and a lease violation. When he later tracked down the prior landlord, the one from 2 addresses back, that landlord said, and I'm paraphrasing, "I would never rent to that person again. The information was available. He just didn't ask the right person." The questions that actually surface red flags. Did they pay rent on time, consistently? Did they give proper notice before moving out? Would you rent to them again? And if you hesitate, I'll know. How did they leave the property? Were there any complaints from neighbors? That last question, would you rent to them again, is the single most revealing question in a reference check. A 1-second pause before the answer tells you everything. Also call the employer to verify employment. A simple call to the company's main line, not the number the applicant gave you, asking to confirm that someone works there in a certain role is perfectly appropriate and surprisingly often catches falsified applications. You've run the application, you've pulled the credit, you've verified income, you've called the references, now you have to decide. And this step, the decision itself, is where the legal exposure either compounds or disappears entirely. Approve based on your written criteria. Full stop. If the applicant meets every threshold you established before you listed, approve them. If you're looking for a reason not to approve someone who checks every box, that instinct is a fair housing lawsuit waiting to happen. Now, if you're denying an applicant, listen closely, because this is non-negotiable under federal and California law. You must send an adverse action notice. This is a written notice informing the applicant that their application was denied, the reason for the denial, and the name of any consumer reporting agency whose report contributed to the decision. This is required under the Federal Fair Credit Reporting Act, and California adds its own layer on top. Failure to provide an adverse action notice is a separate violation, independent of your denial reason. Your denial reason must be tied directly to your written criteria. We found a more qualified applicant is not a sufficient reason when a background check was involved. Be specific, be documented. Keep copies. And about those fair housing violations, this is not scare tactic territory, this is math. The California Department of Fair Employment and Housing can assess penalties starting at $16,000 for a first offense. Subsequent violations go up to $40,000 and beyond. Private lawsuits can layer on top of that. The cost of a fair housing complaint far exceeds the cost of building a bulletproof screening process now. Use the first qualified rule where possible. Approve the first applicant who meets all your criteria. It removes subjectivity. It removes the appearance of comparison shopping among applicants in ways that could be perceived as discriminatory. It keeps your process clean. Here's what you need to walk away with today. Write your screening criteria before you advertise your unit. That document is your legal foundation and your first line of defense. Know what you can and cannot ask on a California rental application. Source of income is protected. Immigration status is off limits. Keep your application form consistent across every applicant. Apply your income and credit thresholds consistently. The 3x rent rule is standard, but only if you use it every time, for everyone, without exception. Reference checks are where the real information lives. Call the prior landlord, not just the current one, and ask the questions that get honest answers. And when you deny someone, send the adverse action notice. Every time, without exception. Fair housing violations start at $16,000, and the paperwork that protects you takes 10 minutes to complete. Screening isn't about finding the perfect tenant. It's about running a consistent, documented, legally defensible process and then getting out of your own way, powered by LeaseBase intelligence.